My favorite lawsuit of the week was brought to us from Ontario, Canada, where a pet sitter who was trying to put rubber booties on a boxer named Forrest Gump got bitten by Forrest. So much to unpack in that sentence. You're trying to put rubber booties on a boxer whose name is Forrest Gump. Interesting. Random. And legal, by the way, because she sued the owners. The pet sitter sued the owners of Forrest for her medical claims, and actually the highest court in Ontario just ruled against her, because under the Ontario dog bite liability law, an owner is defined as anyone who's in control of the animal. And since she was in control of the animal, she couldn't sue herself. Now, I will say that is not how liability works here in the US, where if an owner is aware that their pet has a dangerous propensity and doesn't warn people, they could be liable. But you see lawsuits all the time here in the US, both brought by pet sitters who have been hurt by the animal, and also by owners who claim that the pet sitter was negligent or abusive or stole their stuff. It happens all the time. So the best way to avoid lawsuits is to lay out the intentions of the parties in writing. Create a contract. It doesn't have to be fancy. You don't need to use a lot of heretofores and whereases. Just put it in plain English. This is a contract between the owner and the pet sitter for whatever the dates are that you're going to be doing this. You're expected to put out however many meals, walk however many times a day. You should also lay out what happens, what's the responsibility for the pet owner if the animal is sick or injured, and then sign it so that you both understand the terms ahead of time and can avoid questions that lead to liability in the future. I'm Amy E. Feldman. Amy Explains the Law.